could actually give it.
So does anyone have any big burning questions they want to discuss before I kind of start through the list of things that I emailed out to everybody yesterday? Anyone expecting to get sued that wants to fess up to something? Step into the confessional. Everyone else will close their ears for a minute.
Yep, I will have my back.
Okay. Yeah. All right. So a lot of what I wanted to talk about were follow-ups to the ABR related content, because the content there was very, very good. The instructor was very good, but there were a lot of moments during that day where there were conversation starters that really warranted a bit more detail. The other interesting thing that's beneficial for us locally about getting a speaker from out of the area is it underscores to what extent real estate is a creature of local custom. Because one of the things that clearly caught a lot of people off guard, and I've talked about it here before in the last year or two, was the idea that handling multiple offers is not at all the way that I think a lot of people in our local market think that it is, or the way that became the most common way to handle it back in, say, 04, 05, and 06. So I'll just run through an order of the bulleted list that I sent out. So to what extent can and should you advise a buyer about price and terms in an offer? So Lori, the ABR instructor, had made this point. You don't want to be the one that's advising them at all. The attorney that did the 3-hour continuing ed at the Anaheim convention for NAR last fall had a little slogan, which is, you provide, they decide. So our job is to provide information, and one of the things I've gotten into the habit of doing after listening to the 3-hour risk mitigation presentation, and Lori Cox did a good job reminding me of it, is I will frequently say now when I'm on the phone or corresponding with buyers or sellers, when they'll say, well, what do you think? What do you recommend? Well, one of the keys is we need to not have this complete and utter sense of reliance, because of course if the other party accepts the offer that you recommended, then of course your client's going to think you could have done better, because if they accepted it, naturally you could have gotten another $500 or $500 off depending on what side you're on, and of course if it blows up, then it's your fault. So trying to limit the sense of reliance that the client places upon you, so you want to make sure you're giving the client complete information. You can certainly say, based upon my experience in the past, here's what I have found tends to work better or doesn't tend to work, but I'm finding myself more often saying, but please understand, you're the one, Mr. and Mrs. Seller, who have to tell me what you want to do, whether you want to accept it. It's your call, not mine, but here's what I have experienced in the past. Obviously, every negotiation is different, so based on that past experience, that doesn't guarantee that your result is going to be the same. So you want to try to make sure that you're on record saying something like that without being a complete and utter weasel all the way through the transaction, because obviously you don't want to get to the point where your client's hearing you say, I can't give you advice, when of course they're thinking, what am I paying you for? Any thoughts, any questions on that? Okay, perky interactive.
So what do? You go over the comps with them?
That's the best thing. Go over the comps with them. Or as an example, one of the so to give you a specific example of negotiating strategy that I will discuss, but the way I'll caution the client that, but it's your call, not mine. Frequently, if I'm on the listing side and I'm negotiating a purchase offer that has come in, and I have a seller who says, I've only got about X amount of room that I can negotiate total. So let's say that, that they're willing to concede a total of $5,000. Something that I'll frequently tell sellers is, based upon my experience, even if that is all that you're willing to move, I would rather see you make a larger percentage of that move right up front. Because the primary goal of your first go-round is to keep the buyer at the table. So if your total concession wiggle room is going to be $5,000, I would suggest that you seriously consider $3,500 or maybe $4,000 as the first move, and then make a much, much smaller second move. I understand that you're going to be thinking that doesn't leave me a lot of room after that, but as long as you've left a little room for a tiny move, you'll telegraph that you're putting on the brakes, and so it won't come as a total shock when you do a follow-up very small move and then say, and that's it. Now, there's no guarantee that works, but Mr. and Mrs. Seller, if you don't do a larger move that keeps the buyer at the table, then it really doesn't matter. Everything else is a moot point if your first move is so small because you're thinking, I have to leave enough room for 3 more back and forth go-rounds. Well, that's all moot if the buyer leaves because the first counteroffer is so small the buyer says, I'm not interested. This just isn't going to go anywhere. And then I'll point out, so based upon a lot of experience, that's what seems to work better. Seems to be more important to keep the buyer's attention and then to telegraph in a very deliberate way that you are putting on the brakes, because what you really don't want to do is leave the buyer thinking that you're moving in a particular direction and then say after the fact, oh yeah, that last offer, the last go round, that was final. No, I didn't give you any indication that was the case. I never said anything about it, never did anything that provided that indication, but I'm telling you now after the fact that last offer was final. That's a really bad negotiating strategy. We've been on the other side of it. All of us have been on the other side of it when some moronic either party or realtor on the other side tells you later on when you're still negotiating in good faith, oh no, that was their final offer, I just didn't tell you before. So you can let them know, based on my experience, that tends to work better. You always want to let them know the pros and the cons. You're correct, Mr. and Mrs. L. You won't leave yourself a lot of room if we're going to make a $3,000 or $4,000 move right up front and your total wiggle room is $5,000. But if you don't make a move right up front that keeps them at the table, then it doesn't really matter how much more or less you're willing to negotiate after that. I also have gotten in the habit of following up with emails. I'm not an obsessive note taker. You got people like Brad Coates who maintains a phone log. I mean, he's really obsessive about it, to his credit. I'm not the greatest note taker in the world, and so again, just trying to be more mindful of these sorts of issues of late. I got off the phone with clients last week, and I told them, I'm going to send you a quick follow-up via email just to confirm what it was that we discussed. Just please hit reply on that, because I had already confirmed they were going to be in front of email, so it wouldn't slow anything down. But at least that way I was on record having said, here's what we discussed, correct? Yes, absolutely, go ahead. Or two sellers in different states where it wasn't totally apparent they were on the same page. I finally found myself saying, because when you're counter offering orally and you're trying to boil 4 pages of fine print down to 2 or 3 or 4 variables, but those 2 or 3 or 4 variables are all spinning around just orally in phone conversations or in a text exchange, you may be talking about price, but in the background, closing date had been a couple of different options as well. And so that was one of those things where I had 2 different sellers, both communicating with me via email from different states, and it wasn't 100% clear when I got what I thought was the final counteroffer, but I wasn't 100% clear if that was with the old closing date or the new closing date. And I actually said, I promise I'm not low IQ, I am paying attention here. I just need to be absolutely sure I've got this correct. But then we have a written record of it. So if somebody pops up later, or if the 2 of them pop up not agreeing with each other, which is possible, I'm married, I know how that works, then at least I know from my own correspondence history, I know for sure. And if you're using something like a Gmail-powered email account, you have fantastic archival and search capabilities built into that. So it's always easy to go back later on and track something down in a matter of seconds. So what can you tell your buyer client today about what you learned in failed negotiations on the same property with a previous buyer client? This raises an issue that a lot of realtors don't think a lot about, but we have to keep in mind what the confidential nature of our relationship is. And so obviously the details of a negotiation that we had with a client of ours, even if that person's no longer a client or the negotiations failed and they went on to something else, to the extent that we know something about that seller because of the negotiations we had with another client, the information that we had about that client of ours is confidential unless the client authorizes its release. And so you may know, because and I know we've had at least one agent, at least once in the last few weeks where this had happened. The agent had already been through negotiations on a property, and then and they failed, they fell apart, and then subsequently that same agent ended up with another set of buyers who did end up under contract to purchase that property. And so you end up in this spot where you're going to have some degree of inside information about to what extent that seller may be flexible. You don't know, if you're on the buyer's agent side, you don't know any duty of confidentiality to the seller. And in fact, we all need to be mindful of the fact that the party on the opposite side of the negotiations can spill everything about those negotiations to whomever they want. They have a duty of confidentiality to their own client, but to the extent that their own client authorizes release of information about what the sellers are doing in response to the offer, that there is no duty of confidentiality there. So on the one hand, be very sensitive to the fact that you'll owe a continuing eternal duty of confidentiality with respect to your past client, even if their negotiations fizzle, when you're talking to a new buyer. Now that may mean a quick email just saying, hey, I now have somebody else interested in the property at 123 West White Street. Is it okay for me to fill this client in on kind of how that went before? So not necessarily a big deal to get an okay to do it. Just be mindful that unless we have authorization for release of information that could be construed as confidential, we can't disclose it. But as I said, the flip side of that is if you're working for a seller, or, well, let's stick with the buyer side. If you're working with a buyer and you're in a multiple offer situation, it's perfectly legitimate for sellers and sellers' agents with the seller's consent to shop offers. So that means that the offer that you and your buyer brought, all of the contents of that offer, potentially, including the identity of your buyer client, no matter how secretive your buyer wants to be, could be disclosed by the seller to a whole bunch of other parties. There's no duty of confidentiality there. So that brings up the occasional issue of what if I do have a buyer who has who has special privacy concerns. In that case, you're going to want to make sure that that person is making their offer via a trust or some other legal vehicle where it is possible to completely conceal their identity. Any questions on that? Liz?
How real does the trust have to be?
How real?
Yeah.
Well, it has to be legitimate.
Well, so
I
then.
mean, you can't have a straw man because we obviously have a legal prohibition against that. So it has to be something legitimate. But I mean, there are perfectly legal ways to conceal the identity of the party that's ultimately the beneficiary or the principal that's behind the trust, a legal entity that's been designed to conceal identity. And it doesn't happen often around here, but every once in a while you'll either have somebody who's very high profile, or somebody who just has a heightened sense of privacy, or somebody who has had specific security issues. This didn't happen with my family, but as a child, my family fled town multiple times because people got out of prison threatening to kill my family. Because Dad had sent them there. So turns out some of these people hold a grudge a really long time. So
25 years.
Right. So for example, if you have a situation where you've got a heightened security concern, it's totally legitimate to want to do that. Just remember that unless you've done so in a vehicle where the buyer's identity is shielded, or unless as a sort of the opening salvo preceding the negotiations, you get the seller to agree to sign a non-disclosure agreement. That's another way to do it. I mean, so without having to go through the trouble of setting up some other legal entity, there would be another vehicle for that, which is before we enter into negotiations, we have a non-disclosure agreement so that we have the seller's written assurance that the buyer's privacy and identity will remain confidential.
The other thing to remember about that is that what a seller was willing to do with one buyer at any given time is not necessarily what they will do with another buyer. Their situation can change in a matter of hours, and so you can't rely on what they did yesterday or last week with somebody.
That's an extremely good point. And sometimes, like you said, it could be yesterday or last week. It's not like it takes 6 months necessarily to soften somebody up. Turns out people could do some fast soul searching and come to a different realization on what they're willing to negotiate on. One of the things that Loria discussed in the ABR class is whether you need a signed dual agency disclosure just to show your own listing. So she asserted that yes, you do. Her assertion was you need to have a signed stage 1 dual agency disclosure just to show. I just read all the way through the license law statute last night. I don't believe that that's the case. The paramount consideration is if there's going to be a conflict of interest, you need to make sure you have sensitized the parties in a manner that will prevent them from disclosing any information to you that could be harmful to their position. So disclosure of agency issues, disclosure of ministerial acts, or disclosure of no agency relationship, that's meaningless if the person that you're thrusting the disclosure in front of has already bared their soul to you and told you, I must have this house, I'll pay twice the list price if I have to. Oh, by the way, thank you for sharing, but now that you're done bearing your soul, I'm going to give you a document that lets you know, by the way, I don't have an agency relationship with you, I have no duty of confidentiality, and I work exclusively for the other side. So from a general principle standpoint, keep in mind that when you're dealing with those issues, we need to make sure, because most of us don't carry the forms in our pockets at all times. Most of us are not going to be pulling the form out to get a signature necessarily, but we all need to be sensitive to the fact that you want to head off any possible disclosure of information that could be harmful to a person's bargaining position and make sure they understand the consequences of that. So in my own particular workflow, I don't do dual agency at all, so I don't ever sign the stage 1 dual agency disclosures because I never ever will go through a transaction in a dual agency situation. If I have a buyer client with whom I'm actively working who wants to see one of my own listings, before we ever get to the listing, if it's either one that they've asked to see, or if I can tell that it's actually a legitimate match for their criteria, I'll put it on the showing list. I'll let them know before we get there, this is one of my listings. Please understand I have a pre-existing obligation to represent the interest of the seller on this property. So I'm happy to show it to you because after all, we know that statistically there's only a relatively small chance that a particular house is going to be the one. So I don't want to go to the trouble of referring it out to somebody else just to do the showing, then have it be ruled out in 30 seconds and then have to go to all the logistical challenge. So I make sure that they understand I have a pre-existing obligation to represent the interest of the seller on this property. I'm going to show this to you. If it's one that you have continued interest in or want to see again or want to consider writing an offer on, number one, understand that you need to not say things to me like, my life will not be complete if I do not have this property and I'll pay double the list price if I have to. Don't say things like that to me during the showing. And number two, understand that I have a pre-existing obligation to the seller. And if you want to proceed, then I'll be happy to refer either you or the seller to a different licensee to eliminate the conflict of interest there. Any questions about that?
Yeah.
Okay.
Okay, I thought you had to have something signed when you showed your own property, either no agency or dual agency. I thought it had to be in writing.
If you are working with a buyer with whom you have an agency relationship, by that time you must already have provided at least a written notice of buyer's designated agent. So in this case, in my instance, I'm letting them know for the purpose of a showing, understand what the situation is, and don't disclose anything confidential about it because of the conflict of interest. But at that early stage of the game, remember, just think in terms of how is the worst that it could blow up on you. And if you're going to a lot of trouble to make very, very clear what that situation is, and you've already told them, if you like the property, that's great, and I will make sure that I eliminate the conflict of interest. But for the purpose of at least getting you in the door, just know where things are and let me go ahead and walk you through it. And after all, I have an obligation to disclose any known defects. So if both parties, seller already knows because of a listing agreement, buyer already knows because they've gotten a written notice of buyer's designated agency. Again, reading all the way through the statute last night, it is not clear, it is not at all clear that you must have a written stage 1 dual agency disclosure to cross the threshold of your own listing with a buyer. Now, if you were meeting somebody, if it's a sign call, you'd want to make clear at some point as early as possible, again at a stage designed to prevent disclosure of information that could be harmful to that consumer's bargaining position or intended to ensure they didn't disclose confidential information unwittingly. You'll want to disclose that you're the agent for the seller and try to make clear that at that point you're not representing that buyer. And you want to provide a written disclosure as soon as practicable, but the statute says in no event later than the time that you're writing an offer. Now, with the buyer's note, the written notice of buyer's designated agency, that's supposed to be done as soon as that agency relationship starts. So the example I have given in these meetings before, which is an example, it's an example that either Betsy Urbance or Steve Bohenik, one of the attorneys for IAR, has given, because this is a new thing under the statute that was revised the 1st of last year. But you get a sign call. So I'm going to give you a specific common scenario in our lives. You get a new lien, comes in as a sign call. You say at some point, you know, I'll be happy to show that to you. That's a listing of mine. I represent the seller on that property, but I'd be more than happy to show that to you. You meet at the property. At that point, if the only property they've asked to see, and you haven't had any previous relationship with that person, if the only property they've asked to see is one of yours, then at that point you have no agency relationship with that party. And you'll want to, as soon as practicable, give them some sort of a written disclosure to that effect. You're okay under the law as long as you get a written disclosure no later than when they write an offer. But remember, from a principle standpoint, the idea is make sure you're telling them early enough that they're not going to disclose information that's harmful to them. It's not quite as big a deal at what exact minute you give them a no agency disclosure. It'd be nice if you did it first thing. But of course, if somebody just calls, I mean, put yourself in a consumer's shoes. I called the number on the sign because I wanted to see the house with the sign in the yard, and then I meet the person there and they're thrusting papers in my face that, you know, that look legal in nature. So, you know, obviously we have to use some judgment. Now the law says, of course, we know the notice of designated agency designated agent does not have to be signed by the party. It simply has to be provided in writing. So going back to that scenario of the sign call, no agency relationship exists at that point. You're simply showing your listing. You're working in a listing capacity only. I think, as an aside, I think it is a mistake for people to, as a matter of course, sign a dual agency disclosure at that point. I know some agents do that, but I think that's a mistake, because at that point, there's no reason to limit your ability to represent your seller when this is a buyer with whom you do not have an agency relationship established. So at that point, I would encourage you to treat it as no agency or ministerial acts and still have full-fledged representation of your seller. So you're doing the showing that resulted from a sign call. And while you're doing the showing that resulted from the sign call, that person says, hey, there is a listing in this same price range, or what do you know about the house that's around the corner? And you tell them, and it's in their target price range, and it's listed by somebody else. So under the current license law, technically what you're supposed to do at that moment is, right there on the hood of your car, get out the notice of designated agent, fill it in, because at that moment, when you're no longer showing one of your own listings, you have flipped a switch and gone from no agency to buyer's designated agent. And that's where it does make sense to maybe keep stuff somewhere in your car, a stack of forms where you just fill in the buyer's name and you fill in the date and you sign it and keep a copy, because we have a drop bin outside Vicky's office for those. One of the record-keeping challenges with that particular requirement is that you can imagine from the scenario I just gave, that's a very, very early stage in a working relationship, a relationship that may never materialize into a transaction. So yet, on the one hand, we have the statutory requirement to give this form, to save a copy of the form and keep it in our company's records, and at the same time, there's a very good chance that at that stage of the game, that will never turn into a transaction, and therefore our office will never have a transaction file for it. Because of course, real estate brokerages are accustomed to keeping transaction files. That's the primary way that we sort stuff, and now we have this record-keeping requirement for something that never materializes into a transaction in many cases. So I do encourage you to scan a copy of that, keep it in your own electronic records, or keep your own file, and then we are keeping them, but I don't know how well cataloged they are. There might be a lot of flipping through it if somebody comes looking for a particular one of those. But we're not going to create a new the equivalent of a new transaction folder for stuff that's never turning into a transaction necessarily. Any questions about that? Jim?
Same kind of line, just a little bit different scenario. I get a sign call, it's Ryan's listing, same team obviously.
Mm-hmm.
Paperwork-wise, what happens there?
Well, so if you're working on a team, of course, except under very, very specific circumstances, and even your team where you have the clearest division of labor of any team operating in our market, but even in your case where it's buyers and sellers and there's not a lot of interplay, you still have administrative assistants and files that are all accessible. So you're still going to have to, just like with any other team situation, treat it as dual agency. Basically, everyone on your team is Ryan, everyone on my team is Matt. And so you're going to still treat it the same way you would if it were your listing.
Okay, that's what I thought.
Yeah, so all the same principles apply. And it makes it a little trickier because it's going to happen more often. The bigger the team, the higher the volume, the larger the pool of listings that you're going to have at least the implied conflict on. Liz?
Which is interesting. When I had my office audited by the state, what is it, Scott, who comes in, he said in Chicago, they are not doing dual agency on
within teams?
Right.
So, well then, since you actually had a conversation with somebody who's on the enforcement end of that, did he give you any ideas in terms of what do they look for to help ensure that they don't have the conflict of interest that they would deem something that would give rise to a dual agency disclosure?
We did not go into enough detail, and that's why
Gotcha.
it really is a good question to ask him.
Okay.
Because he made it absolutely clear that when you're on a team, you do not have to do dual agency.
Provided that you don't, provided there's some sort of a firewall.
Right.
If we just locked our listing files, maybe? I don't know.
Well,
Yeah, you don't want to step very far out there and see how much we get smacked around by the licensing enforcement folks. That would be that's the sort of thing we would only want to do that if we had on file something that constituted a formal opinion from IDFPR's enforcement folks. Because otherwise, we run the risk, just like every appraiser brings some human subjectivity to the appraisal process, every IDFPR auditor has some degree of subjectivity, and we sure don't want to be the test case for, was your firewall great enough? I would love to see that work out such that we could avoid the dual agency in those cases, because I think especially in the case of your team where you do have very clear separation, it'd be nice to be able to provide full-fledged representation, because in many cases what's frustrating on a team is, and I'm on a small team, and with Jeffrey and I, it's still, so it's very possible Jeffrey has a buyer who's never met and knows nothing about my seller. Jeffrey knows nothing about the seller. I have never met his buyer. And so, but for the fact that we have shared electronic client folders within our computer network, there really would be no overlap. There really would be no conflict. So, but until and unless we have a really, really firm what amounts to an advisory opinion from an IDFPR enforcement person, we've got to assume that whenever you're on a team, there's the distinct possibility that they'll look at however it is that you have shared files or an administrative assistant that's dealing with the buyer and the seller and say, that's enough of a breach in the firewall that we're gonna say that should have been disclosed to a agency and it wasn't.
So when you take a listing, do you put your team members in on the listing
Yes.
too? So
Yes.
do I.
Yes.
So-
And if you don't, now you wouldn't absolutely have to, but if you don't, then every time you ever had another team member operate in your place, you have a legal obligation to serve a written notice of change of buyer or seller's designated agent. And as a practical matter, one of the advantages of a team is we both or we all will work on your behalf, the very same. And I'll tell that to sellers because when they're seeing multiple names on the listing agreement, I'll let them know, as delightful as Jeffrey is, you may never get the pleasure of meeting him. But that does not mean that he's not still working on your behalf. And there's a very good chance that sign calls that come in will be routed to him, and so he may very well be doing some of the showings on your house. So I make sure they understand how that works. We both do business in my name. He is your listing agent the same as I am. And if I'm out of town or unavailable, part of the advantage, part of the marketing pitch of a team is there's built-in coverage. So if I'm gone or if I'm already swamped in appointments and a call comes in, you can believe that your listing is still going to get shown, nothing's going to be missed. Other questions?
Tons.
Okay, well good.
The reality is it's like a subject in itself.
Oh, yeah.
And I'd be curious, because Coldwell Banker got dinged years ago for not having their pending files locked.
Oh, interesting.
But I haven't seen it since then.
Yeah, and you were there more recently than I was, but I mean, the agents would have a legitimate need to access them, but obviously you then can see information that's not yet public, like what the contract price is.
Exactly.
Right. Bill, do you know anything about that? Have you ever heard anything about
That'd
that?
be the second thing I asked Scott when I called him.
Bill's not talking a lot, but he's writing a lot.
Yeah, credential, we were told not to do that.
Not to do what?
To keep the pending files separate.
I think you were told to keep them separate.
Yeah, so people couldn't sneak.
Right.
Wow, how would you get to them on the weekend and stuff like that if you needed them?
Cutting
That's
torch.
a problem.
Okay, another really, really good issue that came up in the ABR course and also was discussed in the 3-hour CE course at the NAR convention. Can and should you disclose the contents of a previous home inspection report from an earlier fall-through transaction if you're the listing agent, you're disclosing it to future buyers? So here's the conflicting set of answers to that. On the one hand, you're going to have a home inspection firm and possibly the fall-through buyer who says, that's my report. I have rights to it. I paid for it. I paid for it so it would be mine, not anybody else's. And the home inspector probably even has a copyright indication somewhere in the body of the report. So the report itself is somebody else's work product. However, every observation in that report, once you've been made aware of it, becomes, and anything that's a material fact pertaining to the condition of the property, we as listing agents have a very specific and clear statutory obligation to disclose that. That information is very clearly carved out in the Real Estate License Act as not being confidential. So a seller, hopefully you're not going to deal with a situation where a seller's trying to say don't disclose it, but you have to no matter what. And if your seller is telling you not to, you need to cancel the listing. because we don't want to be acting in a way where the seller says, they're violating my orders. Yeah, but those weren't lawful orders. Well, you don't want to end up in litigation with your seller, so you want to make sure you tell your seller, here's the deal. Morally, ethically, legally, you and I both have an obligation to disclose everything that we know about this property. If the seller wants to debate whether some of the findings in that home inspection report were accurate or not, I would still assert that you need to disclose all of those findings, all of those observations, and then feel free to disclose whatever additional follow-up information that that seller obtained. So, most common big dollar example is home inspector thinks there's a cracked heat exchanger. But of course, their standards of practice don't involve taking the furnace apart to the extent that they can get a 100% coverage visual inspection. There are very specific ways to test conclusively for whether the heat exchanger is cracked, and so the seller hires an HVAC technician after the transaction's already fallen through to come through and test for it, and the HVAC technician says that no, it's not. I would strongly suggest that you want to disclose both the initial possible finding that it was, as well as any follow-up information. So the observations about the conditions of the physical condition of the property are not confidential and have to be disclosed if it is a material fact about the condition of the property. So that then gets to the issue of, so should you disclose the whole report? I think there's an argument to be made for doing so, but at a minimum, you need to disclose all of the contents of it, all of the observations. So, all right, fine, I'm not going to hand out copies of somebody's proprietary home inspection report that they haven't authorized me to hand out, but by golly, I'm going to spill it when it comes to every observation that was in there about the condition of the property.
In that same vein, if you have a transaction that falls through because of that, you need to turn around back to the homeowner and they need to make the necessary disclosures as well. And if they're unwilling to do that, then
it goes back to I'm not taking the listing.
Yep.
If they repair,
right?
The sale falls through, but that's after the fact they repair the defects. So what do you feel our legal obligation is?
Well, legal obligation and best practice are two different things. So the question is, what if you had a defect that came up and a seller legitimately repaired it or legitimately believed that it had been repaired, then what's the legal obligation? And the legal obligation answer is different than the best practice answer. If you read through the fine print, and I've discussed this before, we know that we're not allowed to come anywhere close to advising a client how to fill out a disclosure. But one of the most common questions is they'll step into the confessional when you're sitting there with the listing documents, and they'll tell you about everything that's ever happened to the property and then how they fixed it. So what do you think? Should I put it on here or not? And of course, I'll say, on the one hand, you've just signed a document that affirms I am not coaching you how to fill this thing out. What I will do, and I've said to this group before, is right there at the top of the Illinois Residential Real Property Disclosure Report, above the questions, right on page 1, it says very clearly that if a seller reasonably believes a previous defect has been corrected, that there isn't an ongoing obligation to disclose it. So the technical answer is, if it has been repaired, and as long as the sellers truly have a good faith belief that it has been, they don't have an absolute legal obligation to disclose it. So that's the Illinois Residential Real Property Disclosure Act answer to the question. However, when you're thinking in terms of best practices, we know that there are certain types of repairs that you really won't know until a year or two later whether it was really done correctly. You may get a very unusual, horizontal rain pattern that is when the water comes in through a particular flashing in the roof, for example. And what will happen is if a seller knew there was a problem and a seller fixed it and the seller was being diligent and honest and had a good faith belief that it had been corrected, but turned out to be wrong, do you really want to find out that, yeah, legally you were fine and you got to pay several $1,000s to defend yourself against a legal action arising out of the Illinois Residential Real Property Disclosure Act or a fraudulent misrepresentation allegation, a common law? No. Because even if you win, you've lost more money probably than the cost of the actual defect itself. So the best practices answer is, if there was a past defect and there is any possible way that a buyer would think, hey, wait a minute, after the fact, somebody didn't tell me about it and I got screwed over and I need to know who to sue about that. So the best practices answer is disclose, disclose, disclose. Provide all the information about the nature of the repair, but disclose it. That gives that gives rise to another marketing issue, which is there are some agents that will put binders out of the properties that will have the disclosures and everything right there. You may want to not do that, and here's why. If you are erring on the side of over-disclosure, the disclosures normally aren't something that a buyer is looking at carefully until the buyer is ready to make an offer. And at the point that they've already decided, this is my favorite house, this is the one I want to pursue, I'm going to go to the trouble of sitting down with my agent, going through all the steps, all the formalities of making an offer. If at that point they see an Illinois Residential Real Property Disclosure Report that has information about a past roof leak and how exactly it was fixed, or a one-time basement flood because of a power outage or a sump pump failure and the details about the sump pump having been replaced, the worst that's going to happen generally is you'll have a buyer who will stop and have a few follow-up questions or will want to have a conversation about it. But generally speaking, you're still going to get the offer. That sort of thing, when the seller has a good faith belief it's been fixed and provides an explanation about it, very, very rarely will the buyer say, nope, take that back, I don't like this house after all. But the upside to doing that is that seller will have immunized him or herself against any legal action on that type of issue. Because pretty much no matter what happens with respect to that issue after the closing, if they did a full and complete disclosure like that about the nature of the problem and the follow-up fix, if it turns out that the fix, despite the seller's best intentions and best efforts, wasn't effective, they'd still pretty well immunize themselves against liability on the issue. Whereas under the first scenario, they may defend themselves against a lawsuit and win, but they will have lost thousands of dollars in time and money defending themselves. And I've seen sellers do it. Max?
On a transaction that's fallen apart because of a home inspection,
Congratulations.
there were issues on the home inspection that were addressed. What I have done is photocopy the invoices for any work that's been done. You can put it, and now that they've got multiple, you can make your
Oh yeah, we have unlimited attachments in Anovia. So if you didn't all know that, that's a relatively new feature.
Just attach it.
Yep. So when in doubt, go ahead and attach it, and that way, because what's going to happen, of course, is the next person's going to want to make an offer at 9 o'clock on a Friday night when you're not in front of your computer. And if you go ahead and upload all that stuff, you can just tell them, hey, you got access to it already. Here's the deal, but all the invoices are there. But the invoice issue is a very good one, because from our standpoint, going back to something Nick has said, you know, you want to be the source for the source, not the source. And so along those lines, make sure that you're getting contractors who aren't real big into creative writing exercises many times. But make sure you're getting them, because we know for our purposes, it has to have enough detail to kind of tell the story of what was done, what was checked, what was okay, what was not. You know, it can't be something that's just an illegible one-line deal. And if it was just the homeowner having a maintenance service call done, that would be fine. But we know in this case, it's really important, because that's the basis upon which some subsequent buyer will be determining whether there's a material defect with the furnace or whatever the system is. So we should be mindful of what contractors are writing, and don't hesitate if it's not detailed enough. Obviously, don't tell them to write something that's not true, but if it's not detailed or not clear, be mindful of that and encourage the contractor to send you something that's more detailed. And then upload it to Anovia. Because the other beauty there is, it's not public. It's not there for consumers to start browsing through when they're on Realtor.com at 2 o'clock in the morning. It's the sort of thing that you can tell the buyer's agent to access at a point when they're already working with an agent and are hopefully not going to then be scared away by that stuff. Just as an anecdotal incident, I had an offer that went just this past week, and the buyer's agent specifically complimented my sellers and me on the fact that we had a disclosure that indicated that we had had a one-time basement flood issue. And it was a one-time sump pump failure. I can't remember if it was a power outage or a failed sump pump, but the buyer's agent said, you know, the buyers and me, for my part, really felt like that sort of created this heightened sense of trust with people we've never met before, because they obviously went out of their way to disclose more than they would have had to have done.
Then you're also going to, I mean, neighbors love to tell all the good stuff.
That's true.
So that if you don't disclose it, somebody else is going to know.
I saw that water extraction van over there every time they got an inch of rain. Every single time.
Here's your cookies.
Right. Exactly. Congratulations on that house. That's a really, really good point. They're going to find out, and if they find out later, and they think that they got screwed over, whether they did or didn't, they're going to be looking for who to sue. Any other questions?
Just going back, Jay had a good point. Just to reiterate, the the fall through inspection, a lot of the inspectors, this inspection is solely for the use, but when we get the information, once we have actual knowledge of defects, we're obligated to disclose those, but not necessarily share that hidden copy of the report that we have.
Yeah, because you'd be gambling basically. If you shared.
I didn't ask his question right, so forget it.
Well, why don't you ask your question?
But aren't we in a contractual obligation to the home inspector when they sign on that, because that inspection is between them and the seller?
Well, we're not parties to it, but we're seeing a document, because obviously we're privy to a document that we're not one of the contracting parties for it, but we end up with access to it. And so the question is it possible that a home inspector then could make a claim against you for unauthorized distribution of their proprietary work product? Yes, I suppose so. Is that likely? No. If it happened, what's the worst that's going to happen? You may have to pay the inspector another $275 fee. If you don't disclose all of the contents, every material observation, every material fact-based observation in that report, later on, what's the consequence? Thousands and thousands and thousands of dollars. Hundreds of thousands potentially. So, that was the point I tried to make right up front. There are conflicting obligations there, so it is possible that in an effort to be very, very, very transparent on the disclosure side of things, that you could potentially step on a home inspector's toes. But as you're weighing the possible downsides, they're way, way, way different in scale.
And always remember, their report's only as good if it's wrong up to the price you paid for their inspection.
Right. Right. And
part of the issue with the inspectors is that inspection is good for that buyer at that time, and you really shouldn't be using it to market the property or be making it public.
Well, the same can be true of a pre-listing inspection, though. I mean, that's still only true about the observations on that property at that time in a market where sometimes properties are on the market for a year or two. But
if the seller has done that and the seller agrees to make that public as a part of his disclosure, that's different than using the disclosure, using that same inspection 6 months later to say, this is the inspection we had and you can't have any others.
Oh, sure. Yeah, absolutely.
Yeah.
Right. Yeah, I would agree with that.
Have we seen the test cases yet on these listing agents who say that you cannot do an inspection?
I love that subject. Okay, so there's not going to be, I mean, I suppose at some point that an agent that does that could get sued by a seller who realizes they were damaged by that. So the issue is you got a listing agent who says that property's been pre-inspected, no inspection contingency is accepted. That's a bad idea, and I'm not just expressing an opinion. It is an objectively bad idea from a marketing standpoint. And the reason is many of us, probably every one of us in the room at some point has had a buyer who has read that in the public remarks and said, what is this seller trying to hide? They will not even ask to see the property because they've already seen it online and they know the seller is trying to hide something. The seller's of course not, but they know when they read that must mean the seller is trying to hide something. And so in many cases, we probably have clients who never even ask to see a property that has that in their remarks because they're so certain that they're being hosed somehow. So from a marketing standpoint, very, very, very bad. And the thing I will tell sellers is I'll often encourage sellers to have pre-listing inspections. But I will let them know there's two advantages to that. One of them is probably as long as you pick someone who's reputable and non-controversial. Somebody, as I tell my sellers, somebody who if there were not already a pre-listing inspection, somebody whom the buyer's agent would say, that's who I would have recommended as your inspector on the buyer side. So, I mean, that's the ultimate reputable, non-controversial test, is if it's somebody who's going to be on the recommended list of most buyer's agents. So benefit number one is, in my experience, there's about a 65% chance that a buyer, if that's the case, will say, well, I don't need my own inspection then, I'm going to deal with this one. But only about a 2 out of 3 chance. That means 1 out of 3 times a buyer, for any number of reasons, will say, I still want my own inspection. It doesn't mean I distrust your inspector, doesn't mean I distrust the inspection report, but I want the hand-holding experience and I want somebody on my dime walking me through that house and I want them to have some accountability to me. That's fine. Do you really want to turn away a buyer with nice green money who has that perfectly reasonable desire? Heck no. And even if you have the 1 out of 3 chance that the buyer still wants their own inspection, I have one of those happening in 2 hours. Pre-listing inspection already done, buyer's agent's going through because the buyers want another inspection. Even if that happens, the other big advantage that still makes it worthwhile for the seller is every inspector is going to be different. Every inspector can find slightly different items because none of them spend 10 hours there. I mean, they're all 2-3 hour inspections. However, the odds that you will find something new and earth-shattering that your guy missed if you used a decent inspector in the first place are very, very slim. So you will have immunized yourself against major surprises. It will drastically reduce the odds that even if the buyer does want his or her own inspection, the deal will go south. And any items that you find out about Mr. and Mrs. Seller now, when we don't even have the thing on the market, much less a contract pending, it is often a whole lot easier and less expensive to get that to-do list of items knocked out in a leisurely fashion. Or you may be able to even do some of them yourself and have a follow-up inspection to verify they were done properly, than to have an offer that comes in with a 30-day closing. As we've already seen, here we are in March and we've got inspectors booked out 2.5 weeks or more. You get a 30-day closing, an inspection date that's 2.5 weeks out. You get your post-inspection notice with 10 days prior to closing, and items you could have done very inexpensively and efficiently at your leisure instead turn into a 4-alarm emergency where you're having to hire whoever can get it done fastest, which is rarely going to be the most cost-effective. So you still have some potent advantages, but yeah, the possible liability on the part of somebody who just puts out there no inspection contingencies accepted is at some point you're going to have a seller who maybe will realize I was damaged in a way economically that I can actually prove, and I'm going to sue somebody over it.
I think it's the buyer who would be more feel deprived.
The buyer can still make an offer that asks for an inspection.
Right, and that's what we all do.
Right, right.
But the point is, if a buyer or an agent just doesn't say you're entitled to your own inspection.
Not entitled, you can make an offer that reserves for yourself an inspection contingency.
Right.
Regardless of what the listing says, just like you can make an offer with a different possession time frame or a different price. Yeah, I think it's going to be a seller. I think the liability is to sellers, not to buyers. Because what happens is the buyer simply just won't buy it. You'd have to be a buyer who could prove economic damage because of the fact that they didn't buy a property that God himself had intended for them to own and enjoy, and that therefore there was some provable amount of economic damage. Whereas with a seller, it's a lot easier. Hey, you created a marketing impediment that cost me money because you did something in your marketing that made my property get ruled out by an untold number of buyers. But either way, it's a bad marketing idea. And it's frustrating because we all can appreciate the upsides of having stuff pre-inspected. It's just a bad marketing decision. Putting that in the non-public remarks as a preference would be fine. What really kills it is when all these buyers see it in the public remarks and then rule the property out without ever going to see it. And in many cases, good properties. Any other questions on that? Okay, so inspection. We already discussed the next one because Fred asked the question, can and should you disclose defects your seller believes to have been repaired? Stigmatized property issues. It's interesting reading the license law again. So what I put in the email I sent out yesterday, we know we're specifically excused from disclosing certain stigmatized property issues as a listing agent. But what are your obligations when working as a buyer's agent? Well, what Lori had said, who did the ABR course, her words were, she said the license law is silent on it, and that's not true. The license law carves out a very, very, very nice excuse. And the wording is, no cause of action shall arise, i.e. you are immune from being sued for. No cause of action shall arise from a licensee's failure to disclose, and then it lists the typical stigmatized property issues that have to do with the people or the circumstances, not physical issues with the property, like somebody who had HIV/AIDS or the scene of a crime or something like that. And because of the way the statute reads, no cause of action can arise, and it would not matter if you were buyer or seller side. So I think from a legal standpoint under the license law, you're probably fine on either side not to do it. We know on the seller side, if it has a negative impact on the seller or on the marketability or on the value of the property, and we are very explicitly excused from having to disclose it, then don't disclose it. End of analysis on the seller side. Be sure if you're looking at an issue that you think may be a stigmatized property issue that is not subject to mandatory disclosure, be sure to give that a careful look. Be sure to double check the statute so you're certain, because we don't want to err on the side of something that should have been. But if it's in the realm of things that are explicitly excused, like I said, the license law is written so that you are immune. Same would be true of a buyer's agent in terms of liability under the license law. But as a practical matter, as a buyer agent, you don't have the obligation to protect the seller's interest. So the only reason not to disclose is to protect the seller's interest if you're on the seller side. If you're on the buyer's side, and we're working in a reasonably small market, if you are on the buyer's side, even if you're not going to get sued, or possibly if you were going to get sued under some legal rationale that was outside of the license law, but even if you weren't going to get sued, do you really want to have your buyer client move into a house and then find out, because as Bill or Nick had said, the neighbors love to talk. So welcome to the neighborhood, here's your cookies. By the way, did they ever get those blood stains out of the carpet? And if everyone in the neighborhood,
One of the rebels.
if everyone in the neighborhood knew, and you knew, or you should have known, and you didn't say anything to your buyer client, even though the license law says no cause of action shall arise from failure to disclose whatever that happens to be, do you really want to be the person that failed to tell your buyer that so that your buyer first finds out afterward? Because the reality is that could affect market value. And it's going to make you look not very favorable to that client. So the general advice, and this also was stated by the attorney who did the CE in Anaheim, the general advice was, on the buyer side, if it is in your head, disclose it. If it's something that runs through your mind as a possible concern for the buyer, even if it falls within the scope of those stigmatized property issues that you would have absolutely no obligation to disclose as a seller, then absolutely. Now, examples of things where you wouldn't. Obviously, don't disclose something that could be construed as a fair housing violation. Don't say something about the people or about the circumstances if what it could do is create a fair housing related issue. But if it's because you know that there was an infamous crime that took place there, or you know that the last owner hanged himself and the body was in there for 2 weeks before it was found, that sort of thing, where your buyer moves in after closing and finds that out, of course, about 30 minutes after closing, and then thinks that you are fill in the blank, that sort of thing, go ahead, no issue with disclosing, as long as you're not a dual agent. If you're a dual agent, of course, and you've got that, you're excused from disclosure, and you got a duty not to disclose anything that's going to be injurious to your seller's position. Any questions about that? Another example that's not right within that, but was a fact pattern that Lori gave in the ABR class was, for example, finding out buyer's agent who marketed himself as being the local expert didn't mention that the house that he sold his buyer client, so not dual agency, his own buyer client, dedicated buyer representation, happened to be down the street from an infamous biker bar, which during certain hours became just completely ear-piercingly loud, ear-splitting volume. So, there's possible liability there if you were marketing yourself as the local expert and there was a huge, well-known neighborhood nuisance. It doesn't directly affect the physical condition of that property, except for the fact that that there is a nuisance that is very much perceptible when you're on that property at certain times. So just be mindful of items like that. On a related subject, going back to not being the expert, on a related subject, I had an agent quizzing me on whether rural parcels I have listed meet minimum buildable requirements. Well, I happened to have found out when I had 2 adjacent parcels, different owners, totally coincidental that I ended up with them both listed in rural Homer, but I found out that they both had been acquired by the current owners as home sites, and for happy reasons. Neither one plans to build there anymore, and so they're both selling. And I found out that one of those owners did not have minimum buildable requirements met. He had bought it from the previous owner as a building site and had paid accordingly for it. And I determined in talking with the county, it did not meet minimum buildable standards. That's the difference between many tens of thousands of dollars versus a few $1,000s for play space that you can hunt on or run an ATV across. So I knew from probably hours of conversations with county folks and relaying the information to my client, and ultimately the previous owner made that situation right, which was a very pleasant surprise. Paid for all the legal fees to have all of that resurveyed and worked with another property owner to rework access and use some of his own land then to cobble together something that met minimum buildable requirements. So I know better than any other realtor right now that meets minimum buildable requirements. But when another agent calls to quiz me on that, you better believe I am not personally vouching for the fact that meets minimum buildable requirements. What I can vouch for is there are some delightful people that work at the courthouse and at Brookins that will be happy to run through those criteria. And I can say, to the best of my knowledge, because I know that was a hot button issue, to the best of my knowledge, Both of them meet minimum buildable requirements. But you and your client must do your own due diligence. Again, do not allow there to be this heightened sense of reliance, because if something is wrong, you're the one that gets sued about it. Anything else?
You would put that in the listing, is that correct?
What?
What you just said that?
No, but I mean, it'd be marketed as a home site. It's categorized under single-family lots. I wouldn't go ahead and put that in the listing, but when somebody's at, so nowhere am I going to say that it's been confirmed as a buildable home site.
Right.
It's not a platted subdivision, for example, but I make sure that if someone starts quizzing you about it, that you make clear you're going to want to talk to the county to confirm for yourself.
But you wouldn't document that in the listing?
You could.
Verify it?
You
I mean,
could.
just to cover?
You could. You just have to evaluate for yourself. To what extent can you cover your rear end with the requisite disclosures and making sure that you're not creating an undue heightened sense of reliance upon you as the expert when you're not, without creating this complete marketing impediment? Because going back to the no inspection contingencies accepted example, if you throw that out there right there in the listing, it's going to make it look like, oh, well, they don't even know. I don't want to waste my time with it if they don't even know if it's buildable. No, we're virtually certain it's buildable, but I'm not the one that makes that determination. That's really a legal and a county government zoning related determination. So be sure you do your own due diligence before you invest the money. Just like you have to when you're dealing with well and septic issues. Make sure you know that it's suitable for your well and septic system. So balance marketing impediment against making sure you're disclosing at a time and in a way that's that'll ensure that they're not relying on you as the expert. And I'm going to, since we're at the top of the hour, I'm going to go ahead and save the rest of the list for later, because, you know, a sign of a good showman is you want to leave them wanting more.